Right, we're at 10:01, so we'll get cracking. And if others join as we start making the way through, that's absolutely fine. So just to say hello from us. So speaking today, you've got Rona McPherson, myself, and Shaylee Howard, and we're all principal associates here at Mills and Reeve. You can connect directly with us on LinkedIn by clicking or taking a photo of those QR codes that are on your screen. And email addresses and phone numbers will also be on the slides at the end. So today's session is all about the NHS provider selection regime. Hot off the press. It's only recently been published and will come into force on the 1st of January. Just a few housekeeping things to note. So this session is being recorded. And will be made available after to those attending. Please use the Q&A function if you've got any questions. We don't think that we'll have time to live answer questions today, but what we will do is follow up separately, and also any questions or comments will help us to inform future sessions. So please do engage with us. It's really helpful for us, and hopefully we can reciprocate that by answering your questions. As I say, the recording slides will be made available afterwards, and there is an opportunity to give us some feedback as well at the end of the session, and we would really be grateful if you could do that. As I say, it helps us to keep improving, so that would be great. So I just wanted to set the scene really before we get into the nitty-gritty of the provider selection regime. By bringing everybody sort of up to speed, whistle-stop tour of procurement in the NHS, and really this whole provider selection regime has come about through some changes over the last sort of 20-30 years. So in the UK, or in England at least, we've had a change in law and change in policy over the last few years. So with the introduction of NHS Foundation Trusts, and then subsequently the Health and Social Care Act, which also introduced the procurement, patient choice and competition regulations, we've moved into a more competitive market within the NHS itself. And then alongside that, within the EU, we had the first set of public contracts regulations, which 2006, which did introduce a sort of a competitive element, although that was much lighter touch, in particular for the NHS. And then in 2015, whilst we still had our light touch regime, it was much more regulated than before. So the culmination of the changes happening in the NHS in England and the changes in the EU meant that we've had a much more competitive market within the NHS, and a sort of very sort of heavy procurement system, both with the patient choice regs and the PCR regs 2015. The change in legislation last year, so the new Act 2022 that brought about integrated care systems, and also obviously Brexit, has meant that the ambition of moving away from this competitive to a much more collaborative environment has been made easier, and that's now underpinned by the provider selection regime. As I say, that those regulations are due to come into force on the 1st of January 2024. So the regulations themselves are still in draft format and are subject to change, although given their imminent arrival, we think and hope that that's unlikely. Otherwise, you'll be joining us for a further session on Christmas Day. So this webinar will be covering the sections that are highlighted on the screen here. So just to sort of give you a flavour for the structure, we'll be talking first of all about what services are caught by the regime, and then the new commissioning routes are essentially 5, because there are 3 under direct award. We'll talk about key criteria in the standstill period, and then moving on to existing contracts and framework agreements and how they're dealt with under the PSR, transparency requirements, modifying existing contracts, challenging decisions, and finally primary care contracts. I'm going to hand over now to my colleague Shaylee, who's going to discuss which services will be caught by the PSR. Thank you.
Thanks, Charlotte. Good morning, everyone. So I think this is a question we've been asked lots and lots over the last few months. So which services will be caught by the provider selection regime and which will continue under the public contracts regulations, which, as you'll know, is undergoing reform as well. So plenty of change for procurement professionals. And if we could just move on to the next slide. So effectively, the PSR says that it will apply to relevant healthcare services in England, and relevant healthcare services is defined, and there is a list of relevant services in Schedule 1 to the regulations, and it's worth having a quick look at those. They are categorised by something called CPV codes, or Common Procurement Vocabulary Codes. This is a system that's derived from the EU, but effectively categorises services. And this is the system that is being used to determine which services are covered by the PSR and which are not. So having a look at some of those, effectively most sort of primary care services are included, including primary dental services and eye care as well. I think that the NHS England guidance makes that clear. It covers things from rehabilitation, medical practice services, imaging services are also included, cardiology, all sorts. And there is also it's worth noting actually also that ambulance services are also included. There are some catch-all descriptions as well. So health services, hospital and related services, and hospital services are also included. So you've really got to consider whether what it is that you're buying includes any of those things with reference to those CPV codes. And it doesn't include goods, works, social care services, non-healthcare services, or what's called health adjacent services. And the guidance makes clear that that includes things like business consultancy, catering, admin, so anything that is potentially provided in a healthcare setting, but actually doesn't provide healthcare to an individual. So again, I think it's really important that when you're in your procurement planning stage, to really think about what is covered by your contract and which regime it falls under with reference to those CPV codes, and make sure you're very clear in your requirements and your specification that the services are indeed covered by those CPV codes. Sort of related question that we get asked is around mixed procurement. So the guidance does recognise that the reality is that contracts may include several elements, some that are healthcare services and others that are not. And we can see that this is potentially relevant where you've got sort of related social care services as well. And what the rules say and what the guidance says is that you've really got to consider the main subject matter of the contract, and that's with reference to the value over the estimated lifetime of the contract. And the rule is very similar as it is under the public contracts regulations. You've got to consider if there's more than 50% of the value, which is healthcare services, using that definition that we've just discussed, then the contract will be covered by the PSR. The rules also say that an authority has to consider whether the non-healthcare services could be delivered separately. So actually, what are the reasons for combining the two contracts together? Are there efficiency reasons? Perhaps it's a better improved quality, a better experience for the end patient. The authority procuring the services will need to really think about that in advance, so that they can justify coverage under the PSR. And I must say this at least once or twice a day, but the audit trail is absolutely key. And this is an area that we see is where the audit trail is all the more important. And having that evidence to show that you have considered your requirement and you have considered the reasons why you have several elements of the contract included in one, and why indeed they should be covered by the PSR. So I think what this means in terms of practice is thinking in advance about your requirements, and at the strategy stage, making sure that your records do clearly set out what it is that you're procuring. Also, I think it's worth doing lots of pre-market engagement with your service providers to understand what benefits and what innovations that they can provide, and whether that impacts on whether you are procuring a mixed contract, and in turn whether that is covered by the provider selection regime or indeed the public contracts regulations. So the more emphasis I think is put on that earlier planning stage, I think that will hopefully make for more efficient procurement and effectively a better outcome for the end user. So I think that was all I was going to say on coverage. I'll now pass over to Rona, who's going to talk about the new commissioning routes.
Morning, everyone. Thanks, Shaylee. Here are the new processes which authorities will, depending on the circumstances, either have to or be able to follow. Time doesn't allow us to go into great detail on these, so it's very much an overview with a few salient points. So let's have a quick look at each of them. Firstly, direct award process A. This is basically where services can only be provided by an existing provider and there's no realistic alternative. So you actually have to use this one if it's not a new service being set up, there's an existing provider, the authority is satisfied that those healthcare services can only be provided by that existing provider, and it's not a framework. Set out in draft regulation 6.3. So what type of services are we thinking about here? I think the first one that springs to mind is the essential services carried out by NHS trusts under their annual NHS standard contract. The draft statutory guidance, which can be found on the NHS England website, also gives examples such as 999 emergency ambulance services and NHS urgent mental health crisis services. For each of the award routes, we've added links to the helpful process maps that are available on the NHS England site, so definitely have a look at these. The only quibble I have with them is they start the process by checking conflicts of interest are managed in accordance with Regulation 21. I would tend to start by checking first that the PSR does apply to your services, which is noted as the second step. So what does this process entail? The authority awards the contract and then needs to publish an award notice within 30 days of the award. I would take award to mean signature of the contract. Details of what goes into the notice is set out in Schedule 2, and I'll be talking more about notices and transparency later. Direct award process B. So this is patient choice where no restrictions on provider numbers. Again, this is one that has to be used if certain circumstances apply, as set out on the slide. As you may already be thinking, if you're looking at the third bullet point on the slide, this is similar to the any qualified provider commissioning route that currently exists. Be aware, though, that if in relation to patient choice situations, an authority is setting up a pool of providers and that pool is limited by the authority, rather than just being open to any provider meeting the requirements, this route wouldn't be available. You'd have to use the most suitable provider or the competitive process. We'll be looking at those later. Again, we've included a link to the process map for this commissioning route. So the actual award process is not very different from process A, as you can see. It's the circumstances under which they can be used that differ. Schedule 2 of the draft regulations sets out what has to be included in the award notice. Moving on to process C, this is all about sticking with the existing provider. Unlike the other two direct award routes we've just seen, it's not an obligatory route. You can, if the conditions apply, also use the most suitable provider or the competitive process. So we're not tied in here. Choice of process rests with the authority. This slide sets out the conditions that allow for use of this route. And as you can see, there is this considerable change threshold that's referred to, and we're going to look at that on the next slide. So what is a considerable change? The first question you have to ask is, do the new arrangements significantly change the nature of the contract from when it was first entered into? We need to be careful here and go back to our contract, what it looked like at the start. If your contract's grown arms and legs over the years, you may not be able to use this route. However, if there's no material changes, the proposed lifetime value of the new contract is considered. if the lifetime value of the new contract is at least £500,000 higher and 25% higher than the contract being replaced, then this route is not available and you'd have to turn to most suitable provider or competitive process. And the reference to lifetime value for the existing contract again means that contract as originally entered into, not after all the amendments that might have been made during its term. There are exclusions to the application of the considerable change test, and you can have a look at these in Draft Regulation 6. So once a relevant authority has assured itself there's been no considerable change, it needs to satisfy itself that the current provider can deliver the new contract to a satisfactory standard. On what basis is this view reached? Firstly, the authority must take into account the key criteria and apply the basic selection criteria. We'll touch on the key criteria shortly. They're set out in the draft regulations, and I think there's probably a whole other webinar in there. The basic selection criteria, however, are not prescribed but must be decided by the relevant authority. They can relate to suitability to carry out a specific activity, obviously one which is in relation to the contract, economic and financial standing, and technical and professional ability. Now, these might sound familiar to you. They are, in fact, what can be used as selection criteria under the current procurement legislation. So potentially, this crossover may help adapt to the new regime. Authorities will need to ensure, however, that the basic selection criteria chosen are related and proportionate to the subject matter of the contract. So moving on to the most suitable provider process. The quote at the top is from the draft statutory guidance. This process should only be used where the authority believes it can identify the most suitable provider, taking into account likely providers and all information available at the time. Looking at the slide, Process C does appear to offer flexibility, but there's quite a few steps to follow. At the start of the process, it's not obligatory, but the statutory guidance advises pre-market engagement should be undertaken, which, as Shaylee has mentioned, can lead to more efficient outcomes. There's also an additional step here that we haven't seen before in healthcare services procurement, and it doesn't apply to any of the other routes. This is that authorities have to notify the market of the intention to use this process. The details that have to be included in that notice are set out in Schedule 5. And it's not permitted to take any steps towards identifying the potential providers until 14 days after the day on which the notice is published. This isn't referred to in the draft regulations as a standstill period, and therefore it doesn't look like a provider could make any complaints at this stage that the relevant authority should not be using this route. However, the statutory guidance states that the authority, when identifying potential providers, must take into account any provider that responded to the notice about the intention to follow this process. But the content of this notice, as set out in Schedule 5, doesn't actually stipulate anything about expressly inviting providers to get in touch or explaining how to do so. However, if any providers chose to get in touch, they would obviously have to be taken into consideration. So after the 14 days have passed, the relevant authority identifies potential providers with reference to the key criteria and the basic selection criteria. The authority can ask any of the potential providers for further information that will help with its decision making. That step isn't in the regulations, but it is mentioned in the statutory guidance. Once the potential providers are identified, the authority then identifies the most suitable provider, publishes a notice of intention to award, and then, subject to no representation or complaints being made by unsuccessful providers, the contract can be awarded at the end of the standstill period. So if the other processes don't apply to your procurement, it has to be the competitive process. The competitive route is, I think, pretty much as we expect. Authorities first have to decide the award criteria, as you would know in any procurement, but under the PSR, the key criteria must be taken into account and the basic selection criteria must be applied. Then a notice is published seeking offers. What needs to be included in the notice is set out in draft Schedule 8. It's permissible to break your your process down into stages, but this would need to be set out in your Schedule 8 notice. The stages aren't prescribed. So in our view, we're thinking there's nothing to stop you here doing something akin to the current restricted process, where you could assess providers against the basic selection criteria and then move on to the actual award criteria. Potentially, this means that down selection is possible, but an authority would need to set out how that would work in its Schedule 8 notice from the start so that providers were aware of the process. Once offers have been assessed, the winning provider is notified of their success, and unsuccessful providers must be given the information set out in Schedule 9. This includes the reasons why the successful provider won and the reasons why the unsuccessful provider didn't win. We no longer have to think about the relative advantages and characteristics as we do under current procurement legislation. We only have to give the reasons. You also have to publish a notice of intention to award, and note it's not the letters to providers that trigger the start of the standstill period under the PSR, but the publication of the notice of intention. If no representations are made during the standstill period, then the contract can be entered into. So this is a very brief look at the key criteria. They're defined in draft regulation 5, and guidance as to their application is in Annex D of the statutory guidance. Where the key criteria apply, authorities should take all criteria into consideration, but the prioritisation of each in the process, the weighting if you like, is not prescribed. This is left to authorities to decide. However, the reasons for the way in which the criteria are weighted or balanced will need to be included in the decision-making record for the relevant process. For example, an authority would need to explain why it places greater importance on value than on quality and innovation. Authorities will still have to comply with their obligations, though, under existing legislation and statutory and NHS guidance that sits outside of the PSR. For example, the PSR won't cancel out the obligations on NHS organisations in respect of social value and net zero. Therefore, this would have to be taken into account when deciding the prioritisation of each of the key criteria. And now a few words on the standstill period. A standstill period is required in the process as noted on the slide, and it begins the day after publication. My understanding is that it lasts 8 working days. However, there's a potential difference between the guidance and the regulations in the current draft form as to when it ends. The statutory guidance says at midnight on the 8th working day of the standstill period, but the regulations say 8th working day after the day the standstill period begins, which could appear to add an extra day. We've written to GLD about this for clarification, as it just seems a bit odd. I won't say anything here about what happens if representations are received, because we'll touch on this later. Here's a summary flowchart you might find useful, again, taken unashamedly from the NHS England slides. It's probably a bit difficult to view on the screen, but you'll see on the lower left-hand side, there's a link. And you may be wondering about existing contracts and frameworks to which you're a party at the moment. There's no retrospective effect on those arrangements, but if you need to make a modification to a contract or a framework agreement for services which come under the PSR, even if those arrangements were entered into pre-PSR, it's the PSR regulations that will apply to any modifications, and Shaylee will be looking at modifications later on. But what about calling off under an existing contract? For an existing framework, contracts can be awarded without competition or by the competitive process, but the choice must be made in accordance with the framework agreement. If the framework rules don't allow for direct award, then you can't just suddenly introduce it. Just to note that this applies to all frameworks, including those that will eventually be procured under the PSR. It means that either route is possible, but only if the rules of the framework itself allow for it. So if a pre-PSR framework allows for a direct award to be made, then that will still apply. If call-offs entail further competition, then it has to be the competitive process. You'll see on the slide that step 1 of the competitive process is that the relevant authority must determine the contract or framework award criteria, taking into account the key criteria and applying the basic selection criteria. As mentioned earlier, the concept of basic selection criteria is akin to the selection criteria under the current procurement regime. Therefore, that shouldn't pose significant issues, hopefully. However, it sounds like the existing award criteria for further competitions under a framework will need to be amended or rejigged somehow to reflect the key criteria, which could mean quite a bit of additional work for the authority. Of course, it may be that some of the original award criteria will match the key criteria, with a clear example being social value, and it will be interesting to see what authorities are going to be doing here. So the PSR will bring in new transparency obligations. As you're probably already aware from your reading around the PSR, flexibility is balanced against transparency and record-keeping obligations. Although for some of the commissioning routes, there may be less to publish than under the light touch regime. Good record keeping throughout will assist with completion of notices. We haven't got time to go look in detail at record keeping, but in short, records should be kept of all decisions made. If you click on the links we've included to any of the process maps, you'll see that on each spreadsheet, there is a tab showing an example of the decision-making record for that process. Okay, back to transparency. Annex B of the statutory guidance provides a useful summary in table format of all notices to be published. So that's something I'd say have a look at. References to the draft PSR schedules on this slide are to the schedule setting out the required content of each notice. So for direct routes A and B, all you have to publish is confirmation of the fact you've awarded a contract. Route C requires you to publish a notice of intention to award as well as confirmation. Being obliged to publish a notice of intention to award brings the PSR into line with the new Procurement Act when it comes into force, which also includes an intention to award notice. So if you deal with non-healthcare services procurement as well, you'll be prepared for this step under the new Procurement Act when it comes in. Once the notice is published, there's a standstill period as previously discussed. For the most suitable provider processes mentioned, relevant authorities must publish their intention to use this route. For the competitive process, as you'd expect, the opportunity must be advertised, and then at the end of assessment of offers, authorities must publish an intention to award, and finally, the confirmation of award notices. Transparency notices are to be published on the government's Find a Tender Services website. Now, the notice templates that you will have to use when the PSR comes into force are not PSR specific. My understanding is that this is going to change and that we'll either see notice templates specific to PSR or notice templates developed for the new Procurement Act, which will also be applicable to PSR. For the moment, we just have to adapt templates already available. NHS England have got some useful guidance for completing the FTS notices for PSR. There's a link to it on the slide. The guidance shows how the mandatory elements of the various notice templates should be completed, and in some instances, provide some standard form wording that you can use. Now, over to Shaylee.
Thanks, Rona. So this is a question we're commonly asked. Can authorities modify contracts? And I suppose if we just move on to the next slide, what I've done there is just unashamedly, just like Rona, copied the flowchart that's been included in the NHS England slides. And I think this is a really useful summary of all the rules. I'm not going to go through each of these in detail, but I suppose what the guidance does and what the PSR does is recognise that the reality is that often there are changes needed throughout the life of a contract to make sure that the contract is still doing what it needs to do. But also that's got to be balanced against ensuring that contracts are competed and compliance with the procurement regime is sort of maintained, and practitioners are indeed ensuring competition for these contracts and ensuring sort of value for money and efficiency for the public sector. Effectively, the regime is very similar to the one included under the Public Contracts Regulations and later in the Procurement Act. And you will be familiar with sort of going through each of those steps and kind of working out whether your modification is a permitted one. And if that's the case, then you can crack on and sign your variation and continue with delivery of the contract. Or if it's not permitted, then you will need to run a new process and consider which of those processes that Rona's just been through might apply. There were three things in particular that I wanted to talk about. So the test includes consideration of whether the modification renders the contract materially different in character. And this is a phrase that's used throughout the relevant regulation, which is Regulation 13. And we're often asked, what does that mean? And I'm afraid I'm going to give you a rather typical lawyer's answer and say, well, it sort of depends on what it is you're trying to do. I think it has a relatively straightforward meaning. So, for example, if you procured a contract for medical imaging services and that was covered by the PSR, but then you wanted to add on physiotherapy services as well to allow the same provider to then provide sort of potential follow-on services that are required, that, in my view, is very likely to constitute a change that renders the contract materially different in character, because you've got one set of providers who might be able to provide the medical imaging services, and then you have a likely other pool of providers who might provide the physio services. So it's worth thinking about that in advance, and also thinking about that in advance when you are planning your procurement to consider any future changes that might be needed throughout the life of the contract. The other thing to consider is the modification value. So the regulations talk about a threshold of £500,000. That's not to say that anything above that figure is not permitted. So depending on the circumstances, it may well be that you can have a permitted modification, but if it's over £500,000, then you will need to publish a transparency notice. And that's the third thing I wanted to talk about. So if you need to publish a transparency notice, which effectively sets out the details of what you're doing to modify the contract and why, then you've got to do that within 30 days of the modification. And that's quite different to the approach that we have now, in that it will suddenly bring into the spotlight some modifications that might otherwise have gone unnoticed under the existing regime, and that's very much in line with the changes that are being anticipated under the Procurement Act as well. So worth, again, as I say, thinking in advance about what potential modifications might be needed throughout the life of your contract, and if possible, providing for those as part of your procurement, so that you don't have to worry about potentially exposing yourself to risk further down the line when you're seeking to make those modifications. So I think that's all I wanted to say on modifications. I'm now going to talk a little bit about challenging decisions. So this applies to the competitive process, the most suitable provider process, or the direct award C process. And the key thing to note here is that there's no longer a right to raise an action in the courts, and I can almost hear you all cheering that you're not going to have to worry about receiving claim forms, but that's not to say that the right to complain hasn't gone away entirely, and I know Rona's talked a little bit about this already. If there is a grumpy third party sort of disgruntled bidder as part of the process, then during the standstill period, it can contact the procuring authority seeking a review of the process. And it's only those providers who actually could have been a provider of the services and who can show reasonable grounds for why they think the rules haven't been correctly applied. And it's only those sorts of providers who can seek a review. So actually, as part of your engagement with providers, that might be a point where you as the authority say, well, actually, we don't think we don't think you have got reasonable grounds for showing that the rules have or have not been applied correctly. If you as a procuring authority do receive any representations, then you need to inform the preferred provider, and you have to continue keep the standstill period in place while you investigate that complaint. You have to, as an authority, provide information requested, but there are exclusions to this in terms of commercial and public interest. So that's not a blanket exclusion. You will have to think quite carefully about whether any of those apply. Then as the authority, you need to review the decision taken, taking into account those representations made. The reviews, the guidance says that reviews should be carried out by individuals who weren't involved in the original decision. And that's, I suppose, to ensure that there is that level of objectivity when reviewing the decisions. If that's not possible, because we don't all have unending numbers of staff who might be available to do this, then there should be at least one such individual in the review team who hasn't been involved so far. And again, I think this is a point where the audit trail becomes important, capturing those decisions to include relevant people and also what their process was. At that point, once they've done the review, then the authority can decide to stand by its decision, and again explain those reasons why to the complaining provider. Effectively go into reverse gear and, for example, either go back to the start or an earlier stage in the process. So that might be you recognise that an error has occurred and you have gone back to before that decision was made. Or indeed, you might decide to completely abandon the process. And if that's whichever one of those decisions has been made, the authority has to notify the preferred provider and indeed the provider who sought that review, but there's no need to inform any other potential providers if that's not relevant. There is still an option after all of that. So it might be that the provider gets the PSR review panel involved, and that's a panel that's being established by NHS England, and the plan is for them to get involved in considering the issues. It might be that it's necessary to sign the new contract before the end of the review period, and it might be that if the contract does need to be signed, then it's something that the authority sort of notes for next time. The panel also has the ability to determine that the award should be made as originally planned. Again, wind back to an earlier stage or abandon the procurement. And if after all of that, there's still a potential to complain, then I think the only option as we see it would be judicial review, which is long and costly, and that would be based on a failure to sort of to comply with the process. So even though the right to challenge in the courts has gone away, there are still lots of other tools available within the PSR that allow that scrutiny of decisions. So I think that's all from me, and I'm handing back, I think, to Charlotte.
Thank you. Yeah, so our last section is on primary care contracts, and then we'll be summing up and closing the seminar. We've got 6 minutes to go. So I just wanted to briefly touch on how primary care contracts are affected by the PSR. So it's already been mentioned that primary care contracts will fall within the definition of what healthcare services would be covered under the PSR. So question is, when would the PSR be likely to apply to those services? Well, the text in the purple box is taken from the NHS England draft statutory guidance, which envisages that those almost indefinite contracts in primary care are unlikely to be covered, or maybe in certain circumstances, but generally speaking unlikely to be covered under the PSR what I would point you all to is Annex C of the guidance, because that contains really, really detailed and guidance and lots of example situations. So what we've done here is sort of summarised the pertinent points. But if you're in the primary care space, either as a commissioner or as a provider, then we would encourage you definitely to take a look at that section. Circumstances when the PSR might apply in primary care, though, would be planned or unplanned contract terminations, and that would include obviously emergency contracting, which I'll come on to talk about in a moment. Expiry of time limited contracts. So in the case of primary care, we'd probably be looking at the APMS contract for general practice and the PDS contract for dental services. When new services are being arranged, so for example, if you've got a new GP surgery on a new development and a new contract was being awarded in relation to that, then the PSR potentially apply. And we've briefly talked about modifications to existing contracts. And as Sherry said, there's circumstances when those modifications will be permitted in accordance with the guidance and the regulations, but there also may be circumstances when those modifications take you outside of that permission. So just a slightly deeper dive into some of the general practice contracts. We just wanted to flag some of the examples. So as I've said, in the case of GMS and PMS contracts, particularly those with no end dates, then it's anticipated that PSR is likely to mean any significant changes in those in the contracting arrangements for those particular contracts. Where we're talking about APMS contracts, as I said previously, there may be circumstances where the more competitive processes will need to be followed, but there could also equally be circumstances where direct award process C could be used for recommissioning where appropriate. So essentially where you're the incumbent and for all of the reasons that Rona's set out, it's possible for that contract to be further extended. In relation to the DES and the LES, we think that the direct award process B would likely to apply here, but there are situations in Annex C of the guidance that I would refer you to look at, specifically where NHS England envisaged that the more competitive processes might apply. And then finally, just touching on emergency contracts, we just wanted to flag a potential issue, although we think that it could relatively easily be resolved, where a caretaker contract is awarded. So in an emergency scenario, a caretaker contract can be awarded, but it has to be for no longer than 12 months, obviously whilst commissioners get themselves sorted to run an alternative process. But we envisage that where the scenario where you've got a practitioner who potentially is being disciplined or investigated, that could take longer than 12 months to conclude. And so how would you deal with that as a commissioner when you've only got a period of 12 months to to run your caretaker contract? Well, we think that I mean, there's case law that has supported this previously, and we think that it would be unlikely that a judge would be really would penalise a commissioner in that scenario, because the whole point of the PSR is about patience and about service, and in that scenario it would be appropriate to continue with the caretaker contract, so in order to ensure service continuity. So that's that. So it's just some final thoughts in our concluding moments. We just wanted to think about some practical suggestions for commissioners and providers. I think if you're a commissioner, audit trail is the key point here. You need to be clear, you need to document all decisions so you've got a robust audit trail. If you're an incumbent provider, we'd encourage you to start looking ahead at your contract end dates and start planning for that. So, you'd almost want to be making sure that what you're doing will enable your commissioner to continue to directly award under process C. So gear yourselves up for that. Of course, if you are a new provider and you're wanting to get into a particular market, that could be potentially slightly concerning, the PSR, because it doesn't necessarily encourage a very competitive environment. But that we have discussed ways in which you can stay alive and alert to new contracts. Raina's highlighted, for example, you know, those notices that will be published in advance of a new contract. So it's important to keep alert and alive to what's happening. We've talked about is the PSR the answer? I think it's certainly going to change things up, and it's a big shift. Is it the answer? Well, who knows? Let's wait and see. We've got the new Procurement Act as well coming out, so it's all changed. But I don't think we're going to know anything for a period of time yet. But it certainly provides a different way of doing things, and we will be producing further updates and further seminars. So watch out for those in due course. We've enclosed here the very useful links to the statutory guidance, the PSR itself, and those toolkits. And also the slides that NHS England have produced, which you don't really need to have attended those workshops in order to get the benefit of those slides. They're really detailed and really useful. So we'd invite you to give us some feedback in the form that pops up at the end. We'd be really grateful, as I've said. We've received a number of questions, so we'll have a look at those after this session and see if we can respond to those particular queries. And finally, just to say thank you very much from all three of us.